It's preparing. Now we are live on Facebook. Good morning, everyone. My name is Christina Jimenez, and we have Mr. Floyd as well. Say hello, Josh.
Hello, Josh.
And today is our first time using Facebook Live. We are going to do our best to work out any bugs. We've never done this before, kind of excited to have this going, but I'm sure that we will have some technical difficulties along the way. And so for that, I apologize. So my name is Christina Jimenez. I am an attorney over in Texas. We have 3 firms. We have one in West Texas, 2 in the Metroplex. I am board certified in family law. I've been doing this for about 14 years. Floyd, tell the folks a little bit about yourself.
So same thing. I mean, I practice in Texas, all 3 offices. I've been practicing, 9 years now. I think we primarily handle family law cases. We do dabble in some criminal stuff, but primarily handle family law cases. We've tried thousands of cases of all types. And so we're hoping to be able to answer some questions.
Very good. So what we are going to do today is we've kind of gone online. I'm trying to figure out how to look at these comments as well to see if anybody posts anything, asking any questions. Floyd, if you could do that as well, that would be helpful. But we did kind of pull some questions that we had found online from various sources, just to kind of, when I'm looking over this way, that's what I'm looking at, just to kind of get some general information out to the public and to have you guys share. Floyd, mute your Facebook, please. Just to kind of share. To share some general information. So, it's very important to remember that when we're kind of talking about these things, we're speaking in generalities, kind of with just hypothetical information. It is so very important that when you find yourself in a situation like this, and hopefully you don't find yourself in a situation like this, but if you do, that you go out, you find an attorney that you think is going to be able to suit your needs, discuss these issues with you, and really pay attention to all the nuances of a case, because after doing this for so long, that's the one thing that I have come to realize is it's really the specific information about people's cases that can really make a huge difference. So don't just listen to what we're saying. This is kind of general info. Go out, hire a really good attorney that you feel comfortable with, and make sure that you share your story with them so that they can help you. So Floyd, going to the questions. So one of the questions that we had was, can I have one attorney for both me and my wife for an uncontested divorce if we agree on the terms of divorce in Texas? So what say you, Floyd?
Yes and no. You can have one attorney handle the entire divorce, but an attorney can only represent one person, right? I think it would be a conflict of interest to represent both. And so the way I always do it is I'll represent one party, whoever it is I do the consultation with. My job is to primarily look after their interest. I think it would be a conflict of interest to represent both. And so the way I always do it is I'll represent one party, whoever it is I do the consultation with. My job is to primarily look after their interest. I think it would be a conflict of interest to represent both.
No, I did explain. I'm sorry, continue. That was a great answer.
Right, but I don't know where I was now because I kept hearing myself talking again. It was really weird.
So again, technical difficulties. You were saying that it is a conflict of interest for you to represent both.
Yes. So we could draft the paperwork and handle it for both parties, but only represent one in the matter.
Yeah, and so typically what I like to do if in that particular situation is obviously I'll consult with the person that, wants to hire us. And every now and again, I'll get both of them that want to call in and they both want to talk to us at the same time. And I'll say, no, we can't do that. Let me just talk to one party first and engage in that with that one party. And then we will negotiate with the other party. we go through, we kind of get all the terms together. And then at that point, I will reach out to the other party and say, hey, it's my understanding that this is what you guys have discussed. This is what you want to do. Are you okay with that? And if she or he says, yep, and then like you said, Floyd, we draft all the paperwork and kind of facilitate the process. So in that instance, Floyd, I always have this question of, well, we want to get this done like ASAP. We want it done, within the next weeks or so. Is that possible?
It's possible to have the paperwork done, as long as there's no complex issues of any kind. But in Texas, you've got to wait 60 days before you can be divorced. So generally what we do in those cases is we'll go ahead and file the petition, start that 60-day waiting period. In that 60-day period, we'll get all the Rule 11s, orders, everything drafted up, signed off on, and then we're just waiting on the 60th day so we can do the prove up and basically announce to the judge what the agreement is, and then it'll be done.
And a lot of times in those situations, when I know I have that 60-day waiting period, depending on the type of case, and how solid my clients want to make this agreement, or the other side may even want to make this agreement, a lot of times I will encourage the parties to go to mediation. So mediation is basically a process where you can go in, you have a third-party attorney that is assigned or selected to mediate the case. And, I would be in the room with one spouse, and then the other spouse would be in the other room pro se on their own. And then the mediator would kind of talk through the terms. And then he would say, okay, is everybody in agreement with this? Kind of go through the entire process. And then at that particular point, we would sign a mediated settlement agreement. A mediated settlement agreement is binding. And so once that is signed, even if we have to wait those 60 days, everybody's in the clear. We don't have to worry about anybody backing out on the agreement. And I really like it because it gives my clients peace of mind. It gives the other side peace of mind. And really it's just kind of a formality of waiting for the final court hearing and getting that order entered. Cool.
Yeah, well, like you said, depends on the case. Sometimes the deal that they're willing to agree to is so good for our client, we want to get it done within the next day or two before anybody backs out. So it depends on the case, like you said.
So wouldn't you always, if it's a deal that they're going to come to, we want to just enter the agreement, right?
Sometimes I will tell my client, this is terrible for you, and try to persuade them to listen to my great legal advice. But sometimes if at the end of the day they want to enter into it after hearing my peace of mind on it, then fine. But if it's not such a good deal for our client, I'm certainly gonna let them know that this isn't a great deal.
And we do have that a lot, unfortunately. But like you said, at the end of the day, we have to just let them do what they want to do. So next question, can I withdraw the money in my 401k account and give it to my parents so I won't have to divide it and give half to my spouse? Perhaps I should take this question given your last response. So no, please don't do that. And I guess technically the question is, can I? Well, yes, you can. Should you? Probably not. So there are different things that the court can take into consideration when dividing the marital estate. And so even if let's say that you're going to be filing for divorce in a month, and you say, I'm going to go ahead and put all this money into my parents' savings account and withdraw it. If your spouse hires a good attorney, they're going to track all of that. They're going to trace it, right? There's these rules called Rule 194s. And under the rules, you have to turn over those types of statements. And even if you don't turn them over with the Rule 194, there's discovery, there's depositions, ways that we can find out that information. And if in fact you did that, the court could find that you've committed some sort of fraud, They can potentially reconstitute the estate. So basically, let's say hypothetically speaking, you had $40,000 in that 401k. Okay, well, 20,000 of it is technically yours, right? 20,000 is your spouse's. And so if you've given that to your parents and let's say for whatever reason we can't get that money back, then what the court could say is, well, you had 40,000 in that account and there was $40,000 in equity in the home. And so I am going to go ahead and just give your other spouse or the spouse the entire equity in the residence to make up for the money that you took from her, right? And not only could they do that, but that's not really looked upon very fondly. And so I don't think you would be getting a lot of bonus points with the court if you were to do something like that. Floyd, thoughts?
Yeah, I agree. And then you're talking about pre-filing, right? There's also the issues with TROs and stuff post-filing, right? So if one party has already filed, most courts have standing orders. If they don't, generally a temporary restraining order will be signed that will prevent you from doing exactly that. And that's the purpose of the TROs and the standing orders, is so that you don't do that. So if it's post-filing and one of those are in place, then you would be violating a court order also. So, which has a whole nother deal of ramifications.
Well, I mean, what are those ramifications, Mr. Floyd?
Well, you they could file an enforcement against you, and in punishment for enforcement, you can be held in contempt of court. You could be sentenced to jail for 6 months, and you can be fined for $500 for each violation. You could also be required to pay the other party's attorney's fees, in addition to paying all the money back.
Yeah, so can you? Yes, you can. Should you? Please don't. You're just going to make your attorney's life much harder if you choose to take that route.
And 90% of the time, it will not accomplish what you're trying to accomplish.
You know, and that's kind of the unfortunate, and I guess depending on the perspective, it's the fortunate thing that it happens a lot in these cases is typically the attorneys are going to find out, right? The courts are going to find out. And so I try to encourage my clients to just do everything properly. And based on the circumstances of the case, I can get a pretty good idea if it's going to be a 50-50 split or maybe a disproportionate share where one spouse gets a little bit more. And these little tricks and these things that people sometimes try to do, they just really never work out in your favor. So don't do it.
It's not something that you're the first person to think of. We've seen this over and over and over. And so it's something we know to look for, right? We know to pull all the old account statements. We know to go through the bank statements to see where the money's gone. So you're not going to be pulling the wool over anybody's eyes, especially if there's an experienced attorney on the other side. We know to look for these types of things.
Yes, sir. So next question. I divorced my wife in 2004. I signed a special warranty deed so I can take my name off the mortgage. What do I need to do? Yikes.
So you can't sign a special warranty deed to take your name off the mortgage. That wouldn't do that. It'll allow the other party to take your name off the mortgage. But I don't know what their problem is. I guess the other side hasn't. Is that what the question is?
Yeah, so they go on, they say in the divorce decree, it awarded the house to my ex-wife. I now want to buy a house, but I can't because my name is still in the mortgage. I did sign a special warranty deed and I filed it with Dallas County. And
That's
so
what we call the legal term, I think, is cluster, right? Because it really depends on what's in the order, right? Was the person ordered to remove the spouse's name from the house? If so, you can file a motion to compel, potentially motion for enforcement. If not, potentially it's going to be more difficult for you because there's nothing that ordered them to do it.
yeah, and so this is one of those instances where I really encourage people, like when I'm doing consultations or if I'm just talking to a friend or family member, to hire an attorney. And so I don't know why, but for some people, for some reason, people have this idea that they can represent themselves in family cases. And I tell people all the time, I consider myself to be a fairly intelligent person, but if my washer breaks, I'm going to call a repairman, right? I could probably figure it out, but more likely than not, I'm going to screw it up more than what it already is, right? And so I know that lawyers are expensive. I know that we are not necessarily very likable. I get it, right?
Well, you
So, yeah.
I'm pretty
But we are valuable, and this is exactly why. So what I anticipate may have happened in this case, either this person didn't have an attorney or they hired an attorney who was not that experienced, and they did not talk to them about the difference between a deed and ordering the other side to refinance. Okay. So the way that it works is when you have a contract with a mortgage company, that is a binding contract between you and that mortgage company. And even if we come in on the civil end saying, hey, we're going to give this house to the other side, and it's now their responsibility and it's going to be solely theirs, the mortgage company is basically going to say, I don't care. That doesn't really affect me because you have a contract with me. And so you're still on the hook for making sure that that mortgage is paid. And it's also going to affect your credit. And I presume that's what's happening to this person is their debt to income ratio is completely out of whack. And so they've tried to go and get a new home. They can't get finance for that home. And now they're out of luck, right? And so it's just one of these important, so important that you're talking to your attorneys about that. Typically what we try to do in our cases is we say, okay, you have a certain amount of time, right? 90 days, 6 months, a year. I think I've done it up to like 3 years because this dad was wanting just to make sure that the kids and the mom were taken care of. We gave them an extended period of time to go in and refinance it. And if they don't refinance it, to remove the spouse who's not going to be awarded the house, remove their names, then they have to sell it. And that's really the only surefire way to make sure that those issues are resolved. And then the other thing is typically what we would want if you are the spouse that is not being awarded that home, you're going to want the other side to sign what we call a deed of trust to secure assumption. And basically what a deed of trust to secure assumption is it's a document that if they don't pay that mortgage, it gives you the right to go in and take that house back and not take it back. Let me rephrase, to order that it be sold so that they can finally remove your name from that mortgage so you're not liable for it. So yeah, that makes me feel really bad for this person. But again, this is why it's important to hire a good attorney. So next question, we're still dealing with the home. It says, my wife kicked me out of the house. I live in Texas and my wife kicked me out of our home, changed the keys. Although my name is on the deed, what am I supposed to do in this situation? Can I call the police? Are we still married?
So you can call the police. They probably won't do anything because it's a civil matter. If you broke a window and entered into the home, they also wouldn't do anything either because it's your house. So legally, she couldn't kick you out of the house. It's community property. It's owned by both of you. You can forcefully enter your way back into the house. I'm assuming since there was no mention of it, there's no protective order or anything like that that resulted in the kick out. So just if she just locked you out, then you can go back in. If there is a protective order or any type of orders like that, then you need to get an attorney quick.
And yes, you are still married. Just because she kicks you out doesn't mean you're not married.
Oh, I thought he said we are still married. That's not, it doesn't have a question mark.
Oh, I thought it said my dyslexia kicked in. You are correct. We are still married. Very good. Um, so,
But I guess we didn't answer, what are you supposed to do? So if no case is filed, then what you do is get an attorney, file a case, request temporary orders, and request that you get temporary exclusive use of the home, or that you be allowed to live in the home. That's the best way to go about it. But if you don't want to do that, and you just want to forcefully go back to the home, you can do that as well.
yeah, and you typically won't get in trouble with the police, assuming that your name is on the deed, you all are married, because they're gonna say, you know, ma'am, this is his property too, or her property too, and there's really nothing that we can do about it until you guys go to court and the judge says that only one of you have to live here. So, house, is it separate or community property? If I purchased a house before marriage outright with no mortgage, and in the course of marriage, we use community funds for the taxes, is this considered commingling funds, causing the house to become community property?
Do you want me to answer?
I mean, I can answer this.
Go ahead. I answered the last one.
Okay, thanks, Floyd.
I don't want to
So,
know.
purchase the house before marriage. That means
Right.
it's going to be your separate property. So anything that you own prior to marriage is either gifted to you or you inherited during the marriage. It is going to be your separate property, which means that the other side is not going to have any rights to it. So long as, like in this example, they said that the mortgage was paid off, and the only thing that they've done is pay for the taxes for the residents. So the taxes don't really concern me. That doesn't give them any rights to the actual residents. Really doesn't give them any rights to anything, just because they help pay the taxes from community funds. So the house would be yours. Now, let's say hypothetically speaking that you had purchased the home before the marriage, and then there was a mortgage, and you started, you and your spouse started making monthly payments against that mortgage. Then what would happen is you would have what we call a potential reimbursement claim. And so basically the way that that works is any reduction in the principal balance of that mortgage would be subject to reimbursement back to the community. So let's say, hypothetically speaking, you buy this house and you guys owe, you know, $300,000 on this home, and you're married for several years, and at the end of it, you owe, let's just say, $200,000. Okay, so you've reduced that principal balance of that mortgage by $100,000. What that means is one spouse gets 50, the other spouse gets 50,000, right? And so the person who's awarded that separate property residence would have to somehow pay back that 50,000 reimbursement claim at the time of divorce. And you can get that from other assets. You can get a lien on that residence to make sure that it's paid back. There's all different ways to secure that reimbursement claim. But in any event, that house is going to be awarded to the spouse who purchased it prior to the marriage.
These are kind of like bar exam questions, right? Like you
right?
Kind of weird. Okay, go ahead.
I mean, that was kind of simple.
Well, I mean, just like issue spotting. Like, is this reimbursement? Not reimbursement. I guess it's what we do day to day, but seeing it like, you know, I don't know. Go ahead.
Okay, excellent. So my wife and I have a pending divorce that has not been finalized. We both agreed to nullify the pending divorce. We have reconciled and no longer wish to pursue a divorce. How do we accomplish this?
Well, you would just non-suit the case, assuming that there's nothing outstanding that needs to be dealt with. The other party has an attorney. You would both want to non-suit. You would make sure you did a joint non-suit. That way you did non-suit your pleadings and their pleadings stay active. If you non-suited the case, it would undo everything that was done in the case. So if there was any spouse support, child support, anything like that that was awarded during the case, it would just, all that would go away. So you would non-suit the case.
So kind of, I guess on the same track as that particular question. So I always get calls or during consultations where people say, we just want a separation agreement. We just want, I don't even know what I think that's what they typically will call them, like just a temporary separation agreement.
Legal separation.
A what?
Legal separation.
A legal separation. That's sometimes what they'll say. And that doesn't exist technically in Texas. So if things are happening in your marriage and you're kind of like, listen, I just need to have a little bit of peace of mind, and I'd like to have some orders laid down or rules laid down so that we both know what we're supposed to be doing. Don't just write something down on a piece of paper and take it to a notary. If I had a nickel for every single time a client or potential client came in and said, well, I have this paper, and so, he's breaking the law. No, he's not. Because it's just a contract basically that you two have. That's not a separation agreement. And so in Texas, if you want something that is enforceable by contempt, that we can make sure that everybody's doing what they're saying they're supposed to do or they're going to do, then you have to file an original petition for divorce. And then the other side will typically file an original counter petition for divorce. They don't have to, but the original petition for divorce is what gets this party started, right? And then from there, you would draft temporary orders, and that is a quote unquote legal separation agreement, right? It is an order where you guys say, listen, we're not ready to get divorced just yet. We just want to have rules in place. Okay. And that can cover custody. It can cover visitation, child support, spousal support, use of property, insurance. If we're selling something, who's going to get the proceeds? You can put all sorts of things in there. And most importantly, we get a judge to sign it. Okay, because once the judge signs it, if people are not doing what they're supposed to do, then the court has the ability to throw that person in jail, fine them, make them pay attorney's fees. So that's what you want, right? You want accountability when you're making these agreements. And so do that. And it's worth your peace of mind, and it's worth every penny that you spend on getting that temporary order entered. And then, and I've had this happen several times, where we do this temporary order and months go by, and I typically encourage therapy, and especially if people are kind of on the fence on whether or not their marriage is going to work out, go to therapy. My husband and I, we've been married for 14 years. We've been in therapy for 14 years. And all it does is teach you how to communicate with one another, right? Go to therapy. If that works out for you guys, then all we do is non-suit that temporary order is dissolved. It goes away. It's no longer enforceable. And if it doesn't work out for you guys, now we have an enforceable, order that we can all follow, and then we use that until we get to the final divorce decree. Cool.
The only thing I'll add to that is just clarify, I guess. So temporary orders in the situation you were talking about, yes, legal separation agreement, but that's not all it's used for, right? I mean, I guess it kind of is a legal separation agreement, but I always viewed it as more like, let's put a patch on things for right now while we get everything together we need to finalize the divorce, right? And like you said, hopefully we don't have to, right? Hopefully they reconcile and everything goes well. But in a contested divorce case, it's a Band-Aid. This is what we're gonna do for right now, so everybody knows what the rules are while we're gathering all the documents and everything we need to finalize.
Excellent. Yes, sir. So we have a question on the Facebook comments feed. If I file for divorce, how difficult is it to get some sort of spousal support?
I believe she should know the answer to this question. Hi, Greta.
I know, I'm kind of concerned, Greta, that you're asking this question.
We need to do a review.
So Greta's one of our paralegals. That's why we're laughing. So, Greta, in the state of Texas, everyone is going to be eligible for temporary spousal support at the time of filing for divorce. Okay, so there's a difference between temporary support and a difference between post-divorce spousal maintenance. Okay, so the temporary support, basically what the courts are going to be looking at is there a need for you to get assistance to pay your reasonable monthly living expenses. And if there is, so if you don't have sufficient income because you're not working or you don't get child support or some sort of benefits, then the court can look at all of your expenses and say they need to have additional assistance each month until this divorce is finalized. And there's really no prerequisite other than that on a temporary basis. I will kind of add that a lot of courts are not big fans of spousal support. Yeah, that's just something to kind of keep in the back of your mind, but we have been successful, given the right circumstances, getting some sort of support for our clients. As far as post-divorce spousal maintenance is concerned, there are certain requirements. So you have to have been married for at least 10 years. The other side had to have been convicted of family violence. Is it the preceding 2 years, Floyd, or 5 years?
I think it's if you've been married for 3 years with the finding of family violence.
Very good. And then, yeah, and then there's also, if you're disabled or if you have a disabled child, there's all sorts of prerequisites in order to be able to get it after or post-divorce spousal maintenance. But yes, I mean, you can get temporary spousal maintenance in most circumstances, right?
Well, she just asked about spouse support in general, not temporary. So we're going a little more into post-divorce. And those qualifications that you were just talking about, you know, the 10 years to 3 years plus family violence, that's to be eligible for it, right? To actually be awarded it, you have to show that you have insufficient means to provide for your minimum necessities, in addition to having been married for 10 years, right? And so I always tell my clients, like, this is a big difference in spousal support in Texas and like alimony in California, right? So alimony, generally, the way I describe it is one spouse is going to keep up the lifestyle of the other spouse, right? To make sure they still get to drive a Mercedes and all of that, right? In Texas, not so much, right? We're going to make sure you can eat, you have a place to live, and you have clothes. If you can do that, you're not getting spousal support in Texas. So how complicated is it to get in Texas? Depends on a lot of things, right? The length of your marriage, the income of both spouses, and also your judge, right? There's some judges that are just, no, go out and make it on your own. And there's some judges that are a little more lenient with it. So.
Yeah. And I mean, so typically we'll do this thing called a financial information statement. And basically what it does is it outlines all your income and it outlines all of your expenses. And, a lot of times for my men, I'll have, my hunting trips my annual hunting trips, or for my ladies, I'll have, nails and hair and the very expensive stuff to continue to maintain that. And I have found that actually doesn't go very well with these judges. If you're going through a divorce and you're saying, hey, I need, $400 a month for my hair and I need, $1,000 a month for entertainment. Those are not reasonable living expenses. And unfortunately, most of the time, the judge is going to kind of make you cut all that stuff out because like you said, Floyd, this isn't, to maintain your lifestyle. It's to make sure that you're taken care of. So if you're contemplating divorce and if you think that you're going to, take your spouse to the cleaners, they're going to have to maintain all this stuff. That's unfortunately not typically the case. And again, it's so important to go and talk to an attorney in your area because we're kind of speaking from the Metroplex perspective and West Texas perspective, right? But in Houston, the courts there may have a completely different perspective on all of these issues. So go to a local attorney, talk to them, and then see what they would recommend. So we have another question. What if my car is in my husband's name? Can I keep it if we get divorced?
Again,
What?
Karina should know the answer to this question. Hi, Karina.
They're really sweet.
They are, but they do know the answers to these questions.
And Karina does want to
Hypothetical.
clarify that it's only hypothetical. Jesse, no worries.
Jesse would be her
He's just
husband.
helping us out.
Okay. If car's in my husband's name, can I keep it if we get divorced? Yes. Right. If it's purchased during the marriage, it's community property. He can sign a power of attorney, allowing you to transfer it over to your name. So yes, you can.
So, but it's always such a pain dealing with that because I understand. So here's the thing. If husband has a car and wife has a car, judge is going to make sure that everybody walks away with the vehicle, right? But what if I have a husband who is not good at paying bills and is going to get behind on the car payment and, you know, screw up my client's credit?
So we're assuming there's still a loan on the car. Okay. I got you.
Yeah.
Okay.
So if there's still a loan and you give that car to them and then they don't make payments,
I don't know that they could sign the car over to them if there's a loan on it without getting it refinanced, right? I don't think the lender would let them do that.
no, I mean, you can sign a power of attorney over to them without the obligation of it getting refinanced. But here, the other problem with the vehicles is a lot of times it's extremely difficult to get it refinanced because they're upside down. There's very little equity. There's, you know, maybe they have bad credit. And so, you know, it's one of those things that I mean, if at all possible, let's sell the home and, sell the car and get them a new car, have them traded in pre-divorce. You know, we can put in language in the order that if they miss a payment, then at that particular point, you can go in and you can repossess the vehicle. I have questions with regard to enforceability on that particular, you know, order. That just messing with vehicles always makes me super nervous if it's only in one spouse's name. If it's in both of their names, well, they both have an incentive to make sure that it's paid for so that it doesn't ruin their credit, right?
So speaking from Karina's perspective, right, as the wife, if it's a car that she drives, it's in husband's name. You're talking about the issues from the husband's perspective, not from the wife.
Correct.
Okay, I got you. Yeah, if it were in husband's name and Karina didn't make the payments, that doesn't affect Karina. That affects husband, which we don't care about, Jesse. We're here about Karina, right? We talked about that.
We do care about Jesse. You care about Jesse a lot, Floyd.
I do love Jesse.
So, yeah, I mean, the cars always just make me super nervous. But we always try to find a workaround to make sure that both parties are protected, right? That wife walks away with the vehicle, that husband doesn't have to worry about his credit each month. So, divorce mediations can turn negatives into positive. Is there any way to avoid a flurry of negativity and still carry out a divorce? I mean, yeah, there's lots of ways. Just don't be a jerk. I don't know what they're asking here. So I guess they're asking about mediation. Should I go to mediation? Yes, go to mediation. We recommended 9 times out of 10. I have had cases where I thought, no way in hell is this case ever going to settle. And they do with a good mediator, with the right mediator, right? There's something about the cost associated with going to mediation, the idea of sitting down and just really working through these issues and kind of being able to bargain, you know, maybe I don't know, post-divorce spousal maintenance in exchange for property, really kind of determining what's important to you and what you're willing to give in order to get that. Yes, and here's the thing about litigation, guys, is litigation is really fun for the lawyers, right? I mean, I'm sure Floyd agrees. I would much rather be in a courtroom than in a mediation. But it's not typically what's best for clients, and especially if there's kiddos involved, because at the end of the day, once the lawyers are out of it, you guys are going to have to continue to deal with one another, right? And if you go into that courtroom and if you drag each other through the mud, there's kind of no going back from that. Like, I don't know that you'll ever forgive your spouse for putting you through that situation. If you go to mediation, you have the ability to talk through things, bargain for things, and there's not a whole lot of mudslinging in the process. And so go to mediation. And I tell people all the time, just do the right thing. Like, and I know that sometimes it sucks to eat crap. I get it. But at the end of the day, that is the way that typically that's what the judge is going to do anyway, right? Is everybody's going to eat a little bit of crap in the process. And that's how you know you've had a good mediation, because that's what the judge is going to do. And make sure that whatever lawyer you hire, they're having those conversations with you. They're not just listening to you go on these emotional rants and saying, all right, let's go into the courtroom, because maybe that attorney is just looking for billable time, right? Talk to them about, what do you think the judge is going to do? Because that's how you avoid this nonsense of ruining each other and putting your kids and your entire family through this hellhole of litigation.
Yeah, I agree. I mean, litigation is nasty. I don't know how many times I've heard, like, I never thought he would use that against me. I mean, they hold no punches when you go to court, right? I mean, your deepest, darkest secrets that you never thought would be revealed are coming out in court, right? It just gets nasty. Mediation is a much better way to go. If you can settle there, both parents will be reasonable. If you can avoid litigation, as much fun as it is for us, right? Settle in mediation.
So for the record, Mr. Floyd, Mr. Morgan has just said that I was the best lawyer in DFW. So
yeah, I'll speak with Mr. Morgan when we get done here. He and I are
going so we had another question about, if I have a protective order against my husband, will it affect child custody? And the answer is yes. Yes. Go ahead, Floyd.
Yeah, so if there's a protective order, that means that there's been family violence, history or pattern, and judges found that it's likely going to occur in the future. If that happens, the presumption is the person that has been assaulted. It's my husband, so this is mom. Okay, so mom would be appointed as sole managing conservator, which means she would be awarded more of the decision-making rights than the father. She only asked about custody. Yeah, okay. There's a presumption that husband should only get supervised visits. So yes, it will in numerous ways. Also, with regard to property, result in disproportionate division, but that's not what she asked about. Yes.
So here's what I'll say about those situations. Number one, there are several hotlines that you guys can call if you find yourself in a situation where family violence is occurring. There are shelters that you and your children can go to if you find yourself in the situation. And so please, please, please make sure that you are seeking out those resources, because a lot of times I feel like mostly women, but I have had men also who find themselves in that particular situation. They feel like there's no hope and there's no way to get help, and 100% there is. So make sure that you're seeking out those resources, and also make sure that you're reporting this stuff. I cannot tell you the number of times that I have had a client come in and say, well, you know, my spouse punched me, they choked me, they scratched me, they grabbed me, they threw me, they kicked me, whatever. And I'm like, okay, great. You know, so did you file a report? Because we need that in order to prove all of this stuff, in order to get you this protective order, and in order to make sure that you keep custody of your children. And the answer's no. And it's so disheartening, so discouraging. And listen, I understand why people do that, or they feel like they have to do it. But I have had situations where we're making these allegations and there are no reports, there's no photos, there's no third party witnesses. And we go in and we try to convince a judge that all of this stuff really happened. And then the other spouse comes in and they're super convincing and, you know, most of the time manipulative, and they are able to convince a court that nothing happened. And if you cannot prove that by clear and convincing evidence, which is a significant burden, then the court may not grant that protective order. The court may walk away with this perception of you that you're making this stuff up in order to gain some sort of strategic advantage. And so, number one, if you find yourself in that position, get help. Number two, make sure that you're documenting it, because your lawyer is going to want and need that in order to help you get out of that situation permanently.
Yeah, all the time we hear that, oh, I didn't call the police, there's not any witnesses, there's not any pictures. And I always tell them, look, we'll do the best we can, right? But it's not what happened, right? It's what I can prove, right? If I can't prove it, you know, the judge may not believe it. The judge doesn't believe it, then we're not going to get what we need. And it's not so much what we want, right? Because sometimes it's vindictive, right? I want more property, but sometimes it's an actual need. Like, I need this protective order to protect my kids, protect myself, right? Without that evidence, because like you said, the burden is high, right? Without that evidence, we're not going to be able to get there to make sure that you are protected. So make sure you're documenting, calling the cops, all of that good stuff.
So Floyd, I think that concludes our questions for today. So we're going to continue to try to do Facebook Live. Right now we're aiming for Monday mornings at 7 a.m., but sometimes we have court and mediation, and so it might interfere with that. We're going to make sure that we're posting it on all of our social media so that you guys can stay up to date. We will post this on our feed, so that way if you know anybody who feels like or you feel may get some benefit from this information, please feel free to share it. And like I've said several times throughout this this video, is make sure that you're consulting with a good local attorney. Find somebody who you feel comfortable with, that you think really understands your needs and what you're after. This is meant to just be general information, but it by no means is going to be applicable to every single circumstance, because the nuances are what is important. And thank you to all of our lovely friends who commented and asked questions. We really appreciate you guys. Y'all have a wonderful week.
Bye.